This is an audio for the Common Law Community Training Manual, and the purpose of this is to basically give everybody a chance to learn about common law and be trained in common law. And you can do it while you're listening, while you're cooking, driving, or just sitting around listening to something. You can listen to this. So this is a common law community training manual. It establishes the reign of natural liberty, the common law, and its courts. So it's a community training manual, and it's issued by the International Tribunal into Crimes of Church and State from Brussels. What is assembling is our first court in history to bring judgment against the Vatican and the Crown of England as institutions. But this court, the Common Law Court, also signals the dawn of a new notion of justice, one defined by the people themselves, and especially by the historic victims of church and state, to bring about not only a judgment on their persecutors, but a new political and spiritual agreement to undo the systems responsible for intergenerational crimes against humanity. Now that's from the founding charter of the International Common Law Court of Justice, September 1, 2012.
Sorry, I was just opening something because I wanted to just do a little bit of an introduction. What I wanted to point out is that our governments are run by Roman law, and Roman law basically says that there are rulers and rules. And common law, under common law, you are innocent until proven guilty. However, under Roman law, you are guilty until proven innocent. And what we need to do is we need to go back to common law so that we know and are able to live by the rights as a human being and not as a fictitious person that was created through our birth certificate. So here's a little bit of the introduction to this community training manual on common law. History was made on February 11, 2013, when the first Catholic Pope in history resigned from his office during peacetime in order to avoid arrest for protecting and aiding child-raping priests. Barely 2 weeks later, the same Pope Benedict, Joseph Ratzinger, was found guilty by the International Common Law Court of Justice for crimes against humanity, including child trafficking. And the arrest warrant that he had anticipated and which provoked his resignation was issued against him on February 25. Evading justice inside the Vatican, Ratzinger is presently an international fugitive from the law and a living example of the power of common law courts to successfully prosecute so-called heads of state. The lawful verdict of the International Common Law Court of Justice was a shot heard around the world and has spawned efforts in 21 countries to establish similar popular courts of justice to reclaim the law from the wealthy and their compliant governments. You can learn more at itccs.org. This manual provides instruction and training to those of you who have moved from words to actions. We speak to those who not only recognize the permanent war being waged against humanity by a global corporate tyranny, but who are actively engaged in dismantling that murderous system as its source so that justice can be made real in a reclaimed world. You are part of a growing movement to create a new, liberated society within the shell of the old by first allowing the law to act for all people and not a clique of judicial specialists and their friends. That new society is emerging through every act of courage and integrity by we who know what is at stake, and that is our children and the future of our species.
So why are we taking action? Freeing ourselves by remembering the true law. Man is born free, yet everywhere he is in chains. That fact has altered little over the centuries, but the chains of oppression over much of our species have been forged through the weapons of violence and ignorance, and they can be undone. Long before any rulers held sway over humanity, Men and women established customs and laws among themselves to ensure their peace and liberties as free, self-governing people. They did so from an inherent recognition of a natural law of equity or divine law where no one has any right to dominate or rule over others, to seize more of creation than another, or to own any part of a world given equally to all people. It is the divine principle of creation that every child is born endowed with unalienable liberties that no authority, law, government, or religion can diminish or abolish. Any power that attempts to do so is tyrannical and illegitimate, even if it operates according to its own laws, for such tyranny is a denial of the natural order and an attack upon divinity and humanity. Two great principles summarize this natural law. The first, all things exist and are held in common. By the state of nature, no one has any more of a claim to the earth than another, as noted by a founder of modern law, Thomas Hobbes. I demonstrate in the first place that in the natural state of men, which state we may properly call the state of nature, all men have equal right unto all things. And number two, the law does harm to no one. Arising from the Ten Commandments and God's law to do no harm to one's neighbor, this principle forms the basis of modern law. John Stuart Mill articulated this principle on liberty, where he argued that the only purpose for which power can be rightfully exercised over any member of a civilized community against his will is to prevent harm to others. And this was stated by John Stuart Mill in 1869. An equivalent idea was earlier stated in France's Declaration of the Rights of Man and of Citizen of 1789 as, liberty consists in the freedom to do everything which injures no one else. Hence the exercise of the natural rights of each man has no limits except those which assure to the other members of the society the enjoyment of the same rights. These limits can only be determined by law. The natural law exists to maintain the natural peace and equity between people and is their shield and protector against unjust rule, rather than a force over them. Within the ancient traditions of tribal communities, especially in the Anglo-Saxon world, this law evolved into what became known as the customary or common law, or the law of the land. It has strong echoes in the customs of indigenous nations all over the world. Here's a basic summary of the nature of true or common law versus arbitrary law. Natural liberty and the basis of common law courts. Here are the first principles.
Every man, woman, and child is born and is by nature free, equal, and sovereign, and possesses an inherent knowledge of what is true and right. Accordingly, no one can be subordinated to another or to any external authority, since every person's inherent wisdom and liberty make them complete and sufficient creations in themselves within a wider community of equals. 2. This personal sovereignty is a reflection of the wider natural law, whereby all life by nature is indivisible and placed in common for the survival and happiness of all. In any just society, this commonality endows all people with the unalienable right to establish among themselves their own governance and defend themselves against any tyranny or violence, including that inflicted by external authorities. Any authority that rules unjustly and arbitrarily without the free and uncoerced consent of the people has lost its right to rule and can be lawfully overthrown. Unjust government is not government by tyranny, a quote by Plato. This natural law gives rise to customary common law, whose purpose is to protect the inherent liberties and sovereignty of men and women and children in a community by maintaining equity and peace among them. The common law derives its authority from the people themselves and from the capacity of the people to know what is just and to judge right and wrong for themselves. This capacity is expressed in a jury system of 12 freely chosen people who are the ultimate judge and authority under common law and its courts.
Historically, common law arose in England after the 11th century Norman conquest as a bulwark in defense of the people against the arbitrary rule of self-appointed elites, especially monarchs and popes. The authority of these elites was derived unnaturally from warfare, violent conquest, and the theft of the earth, rather than from the consent of the community and its basis, the divine law of peace and equality. This elite rule arose mostly in the Roman Empire and its descendant, the Church of Rome, under whose beliefs God is a dominator and conqueror, and all the people are subjects of the Pope. Such a conquest-based rule of papal and kingly elites gave rise to a legal system known as civil or Roman law, and the belief that men and women are not endowed with the capacity for self-rule and wisdom. All law and authority is therefore derived externally from the statutes devised and imposed by a ruler, whether a pope, a monarch, or a government. This system developed from Aristotelian philosophy and Roman property law, in which creation is divided and human beings are treated as chattels and the possessions of others, and are thereby devoid of inherent liberties. The people are thus in every sense enslaved, cut off from the world given freely and in common to all. This slave system ranks and categorizes all people and grants restricted freedoms that are defined and limited through statutes issued by rulers.
We're on item number 6. This is common and civil Roman law are therefore fundamentally opposed and are at war with each other. They cannot be reconciled since they arise from two completely different notions of humanity and justice. Common law knows life as a free gift given equally to all, while under civil law, life is a conditional privilege and humanity is a managed slave populace. Accordingly, governments operate in practice according to civil statute law and denigrate or ignore common law altogether through the rule of unaccountable, judge-dominated courts. The most extreme form of elite-based civil Roman law is what is called papal or canon law, which defines the Church of Rome as the only legitimate authority on earth, to which all other laws, people, and governments are subordinate. Canon law is self-governing and completely unaccountable to anything but itself. Behind its front of Christian rhetoric, Roman Catholicism is a neo-pagan cult based on the late 3rd century Roman emperor worship system known as Sol Invictus, in which one sovereign entitled God and Master rules heaven and earth, specifically the Pope. This tyrannical cult has not surprisingly caused more warfare, genocide, conquest, and murder than any other power in human history, and continues to constitute the single greatest threat to common law and human liberty.
The Church of Rome was first and is the oldest corporation on our planet, a legal entity designed for the protection of tyrants, which nullifies the individual liability and responsibility of the elites for any crime or conquest they perpetrate. From Rome and the Vatican, Incorporated has spread the contagion that now threatens to destroy our planet and our lives, as unaccountable corporate oligarchy everywhere subverts liberty and the health of our planet by subordinating all life to profit and power. At this very moment of corporate conquest and its subjugation of humanity, a counter-movement is arising to reassert the divine purpose and its operation through the common law. and to restore the earth and humanity to their natural being as a common body. This movement is foretold biblically and in prophecy as the time when all people are returned to their natural equality, devoid of all divisions, privileges, and oppression, in order to live in harmony with creation and one another. This restoration of humanity is a divine purpose and begins by actively disestablishing all existing authority and institutions derived from Roman civil law and replacing them with a new governance under common law jurisdiction. The creation of that new natural law authority among a liberated humanity is the fundamental purpose of the common law courts.
Okay, how do we use the common law? The truth is that throughout everyday life, people everywhere use and rely on common law to live and work together. It is simply the inherent way that people conduct their affairs together. Liken it to the roots that bind together human communities by unconditionally upholding the life, dignity, and well-being of every man, woman, and child. These roots are especially necessary and foundational in the face of tyrannical powers that seek to subvert such natural freedom. The common law's firm horizontal guarantees of mutual respect and protection are a permanent threat to the efforts by arbitrary rulers to harness men and women into the unnatural and vertical arrangement known as the state. That is why every government and religion seeks to annul the common law with their own authority and statutes in order to reduce free peoples everywhere to the state status of regimented, obedient, tax-paying, wage slaves who serve a ruling clique.
To extend our everyday reign of common law into all areas of life means to challenge the arbitrary rule of those cliques and all state-level regimes. But the very fact that it is the law of we, the vast majority of humanity, means that it only needs to be consistently practiced by enough of us for arbitrary authority and dangers to crumble. We use the common law by simply employing and relying on it in all spheres of life, and that means, first, by establishing functioning common law courts with absolute and ultimate jurisdiction over every aspect of our lives and communities. Matters before a common law court. Traditionally, law in the European tradition falls into two categories, civil and criminal law. The former deals with disputes between individuals, often called tort offenses, or issues of negligence which cause harm. Criminal law deals with acts of intentional harm to individuals, but which, in a larger sense, are offenses against all people because they somehow threaten the community. Arising as a defense against absolutism and state or church tyranny, the common law traditionally has dealt with criminal law matters that crown or canon law courts refuse either to address or do so in a restricted manner, including murder, rape, warfare, and other crimes against the community. But civil matters of personal disputes may also be brought into a common law court, which, after all, claims universal jurisdiction over all legal matters within a community. Indeed, because common law is rooted in the jury system, what better form can there be for settling of civil matters between individuals than a trial before one's own neighbors? For our purposes, however, the major focus of litigation before our common law courts will be on criminal law and matters involving serious threats or crimes made against people, animals, communities, and the environment. As in every lawful system, the burden of proof in any such litigation brought before the common law court will be on the plaintiffs, those bringing the lawsuit, and normal rules of evidence will apply. For example, allegations against a party cannot be made in court without there being a basis in provable facts, such as primary documentation that is certified by an independent party, or by producing eyewitnesses to the alleged crime. Another crucial rule of evidence is the inadmissibility of hearsay evidence, as in, no, I wasn't there, but I heard about what happened. This is an especially relevant rule when it comes to the commission of serious crimes such as murder, genocide, or rape. In short, any allegation must be backed up with provable facts and must be made by one who was a direct participant in or an eyewitness to the event. For our purposes, it must be noted that in the case of especially monstrous corporate crimes committed by governments or other powers, such as wars of aggression, genocide, or human trafficking, normal rules of evidence are less stringently applied. This is because of a realistic understanding that crimes committed by entire societies or regimes are of a different nature than crimes by isolated individuals. A different set of norms regarding intent and provable evidence applies. In the words of the chief American prosecutor at the Nuremberg trials in 1946, Robert Jackson states, "No regime that seeks the extermination of entire groups of people generally retains written proof of their intent to commit this crime. Considering the murderous nature of their regime, there is no need, since such extermination is not considered a crime. Nevertheless, even such a system seeks to fog and dissimulate the evidence, especially during wartime. The proof of crimes against humanity generally lies not in documents, but in the witness of survivors, in mass graves, and in the implied proof of the intent to commit these crimes contained in the everyday and institutionalized laws, attitudes, and norms of the murderous regime." Implied intent is a legal concept especially relevant and specific to litigation involving genocidal regimes, including governments and churches whose worldview and laws consider other groups to be unworthy of life or equal rights, such as the groups that were tried and sentenced in the first case of the International Common Law Court of Justice concerning the genocide of Indigenous peoples in Canada by church and state. And for more information, you can go to www.itccs.org for that. Laws such as the Indian Act of Canada, which impose a different set of laws on a racially targeted group, or the Roman Catholic canon law called Crimen Sollicitationis, I don't know if I said that right, which condones and facilitates the concealment of child rape within the church, indicate a clear implied intent to commit and abet criminal acts. That is, it is unnecessary to prove the individual intent to harm children by Catholic priests, since under their own self-regulating rules called canon law, every priest is systematically required to harm children by aiding those who do so if he is to retain his job and ordination. The collective guilt of these clergy as a whole is implied and clear, just as it was concerning all of the servants of the Nazi regime. Thus, while normal due process requires that prosecution prove that the accused committed an act and did so with deliberate intent, such an intent may also be assumed to exist by the larger context of a crime, especially when that crime is perpetuated by entire organizations or regimes. Ascertaining the truth is always laborious, but ultimately the process is best guaranteed by a body of jurors than single adjudicators. Common law juries and not individual judges are invariably a better guarantee against the abusive rules of evidence and just procedure in a courtroom. Self-governing judges are notoriously prone to corruption and political manipulation, and when appointed by the very governments under criminal investigation, are obviously unsuited to the task of rendering a fair judgment. In fact, under legal procedure, such state-appointed judges have no jurisdictional competence to rule on the criminality and guilt of their employers. Judges routinely waive just procedure and rules of evidence and are authorized to do so by statute law. In Canada, Crown-appointed judges even have the power to alter or destroy court records, silence one party in a dispute, and ignore due process altogether. The whole point of establishing a jury-run common law court is to prevent such manipulation of the law and justice by unaccountable parties or vested interests. It is not accidental that a founding father of the American Republic, John Hancock, declared in 1777, and I quote, "If we have not courts that are established and maintained by the people, rather than by bribable judges, then we will have no republic. Our Constitution and our nation will rise or fall according to the independence of our courts."
The Common Law Community Training Manual, and we're going to begin with establishing and maintaining common law courts. The common law's first principles establish its general legitimacy and lawfulness. This valid system gives rise to courts with the power to protect the people as a whole by prosecuting and indicting any persons and institutions that threaten the community. The mandate to establish such courts is derived from the sovereignty of the people as a whole, and not from any particular political system or government. Common law courts are therefore universal, not constricted by customary borders or laws, and are jurisdictionally competent to adjudicate any issue or grievance. Common law courts are not subject to and do not recognize any other legal or moral authority, immunity, or privilege like those routinely claimed by heads of churches and states. Enjoying universal jurisdiction because of its rootedness in the natural law, common law courts can be established in any country or community, and not only within nations with a specifically common law legal tradition such as England, Canada, and America. Common law courts are established when any number of men and women come together to judge a matter of concern to them and to their community. Thus, such courts are invariably and naturally linked to political movements, town hall gatherings, and tribunals of conscience that unite citizens and give direct voice to their concerns and demands. The court is thereby the expression of that voice.
The court itself is established by the direct will and vote of the people as a whole, who elect citizen jury of at least 12 people, a citizen prosecutor to conduct the case on behalf of the people, a presiding adjudicator whose job is strictly advisory, and a sheriff and a group of peace officers to enforce the summonses, warrants, and verdicts of the court. Additionally, the community may appoint local magistrates versed in the law known as Justices of the Peace, or JPs, who traditionally have the power to summon juries and issue warrants. The JP may also initiate the formation of a common law court. All of the participants in the common law court must present their own case in all of the court proceedings, since to allow another to represent them would constitute a surrender of their natural rights and sovereignty. This applies both to plaintiffs and the defendants involved in any matter before the court. There are, accordingly, no professional lawyers or permanent presiding judges in a common law court system. There is no restriction on the power of a common law court to access any person, place, or thing, nor any limitation on the duration or rights of the court. The court and its magistrate can issue public summonses that are binding on any person or institution and enforceable by the court sheriff, who has an unrestricted right to detain any person named in the summons and to bring them into court.
The final verdict of the common law court jury is final and not subject to appeal, simply because a reasonable and non-coerced group of citizens can come to the truth of any matter on the basis of the evidence alone, possessed as they are of an inherent knowledge of right and wrong. The truth is not mutable. A defendant is either innocent or guilty. The truth is not subject to revision or reconsideration, since then it is not true. However, if it can be proven beyond the doubt that the court's verdict was made unlawfully, was unduly influenced, or occurred on the basis of incomplete or faulty evidence, a common law magistrate can reopen and retry the case with the normal jury and court officers. In the same way, the sentence of the court is also final and is enforced not only by the court sheriff but by all citizens. For the common law arises from and is the direct responsibility of all people, as are all of its procedures. The verdict really is a declaration of the people that they will govern themselves according to their own democratic law and decisions. There is no restriction on the power of a citizen jury to impose the sentence on any person, group, or institution. The court adjudicator or magistrate has no power to alter, influence, or direct the original verdict or sentence of the jury, simply to advise the jury on legal procedure and points of law. Finally, upon issuing its final verdict and sentence, the common law court jury is automatically concluded and its members are released from their duty. No court is maintained without the conscious consent and participation of the people themselves. Again, there is no professional, permanent cast of either lawyers or judges in a common law court system, but rather elected and temporary court officers.
Now we get on to the legal procedure and court protocol. Common law, being derived from natural justice, bases its legal procedures on the centrality of due process, the threefold right of anyone to be notified of the charges being brought against him, to see the evidence in such a suit, and to be tried and judged before his own peers. No legitimate trial can proceed, nor can a conviction be rendered if the accused has not been given these rights, and afforded the chance to freely defend himself in a court of law. Such rights are based on the fundamental doctrines of the common law.
1. It is presumed that the accused is innocent, not guilty. 2. The burden of proof of the accused's guilt rests not upon the defendant but the plaintiff, who must convince a jury of the guilt of the accused beyond any reasonable doubt. And 3. The accused cannot be detained without due process, but must appear promptly before court according to the principle of habeas corpus, Latin for produce the body. Both sides in a dispute are given equal time to file their statements and evidence, make motions to the court, and respond to arguments. But to avoid vexatious litigation designed to simply harass or disrupt an adversary, which can drag out and impede justice and due process itself, the court normally sets a strict time limit on pre-trial proceedings, after which the trial must commence.
The pre-trial period is designed to allow both sides the opportunity to present their evidence and arguments to one another in order to seek a settlement prior to a court appearance. This presentation is usually referred to as examination for discovery, or voir dire, to see and to say, whether either party can demand any relevant evidence or documentation from the other. If examination does not produce a settlement of differences, then the court is convened and a trial begins. The general procedures and protocols of a common law court are summarized in the following outline, which must be followed by anyone seeking to accuse and try other parties.
Step 1. Compiling the case. A statement of claim must be produced by those bringing a case, known as the plaintiffs. Their statement sets out in point form the basic facts of the dispute, the wrong being alleged, and the relief or remedy being sought. Next, the plaintiff's state of claim must be accompanied by supporting evidence, documents, and testimonies proving their case beyond any reasonable doubt. This evidence must be duly sworn by those not party to the dispute in the form of witness statements, and it must consist of the original documents themselves and not copies. As well, anyone whose testimony is used in this body of evidence must be willing to come into court to testify and affirm in their own statement.
Step 2. Seeking the remedy of a common law court, filing a notice of claim of right. After gathering his case, a plaintiff must then seek the aid of a common law court and its officers. Such a court can be brought into being by publishing a notice of claim of right which is a public declaration calling for the assistance of the community in the asserting of the plaintiff's right under natural justice to have his case heard through the common law by way of a jury of his neighbors and peers. Such a notice can be published in a local newspaper or simply notarized and posted in a prominent public location like a town hall or library.
That notice of claim is available in Appendix B, court documents of this manual. Step 3, forming a common law court. Within 24 hours of the issuing of such a notice of claim of right, any 12 citizens of a community can constitute themselves as a common law court and its jury and must then appoint the following court officers from their ranks. A court adjudicator to advise and oversee the court. A public or citizen prosecutor to conduct the case. This person is normally the plaintiff himself or someone he authorized to advise but not represent him. Defense counsel to advise but not represent the accused, a court sheriff, either elected from the community or delegated from among existing peace officers, bailiffs, a court registrar, and a court reporter. It is assumed that people with knowledge of the common law and legal procedure will act in these capacities, and, as mentioned, a common law magistrate or justice of the peace may also initiate this formation of a common law court.
Step 4. Swearing in and convening the jury of court officers. Oaths of office. Upon the appointment of these court officers, the adjudicator, a justice of the peace or a comparable magistrate, will formally convene the court by taking and administering the following oath of common law court office to all of the court officers. And it goes like this. I, then you state your name, will faithfully perform my duties as an officer of this common law court according to the principles of natural justice and due process, acting at all times with integrity, honesty, and lawfulness. I recognize that if I fail to consistently abide by this oath, I can and will be removed by my office. I make this oath freely, without coercion or ulterior motive, and without any mental reservation. After taking this oath, the jury members, court counselors, sheriffs, bailiffs, and reporter will then convene and receive instructions from the adjudicator concerning the case. The adjudicator is not a presiding judge or a magistrate, but an advisor to the court, and has no power to influence, direct, or halt the actions or the decisions of the jury or other court officers, except in the case of a gross miscarriage of justice or negligence on the part of other court officers. Thus, the court is self-regulating and dependent on the mutual respect and governance of all of the court officers and the jury.
Step 5, pre-trial conference. The adjudicator brings together both parties in a pre-trial conference in an attempt to settle the case prior to a trial. If a settlement is not achieved, both parties must then engage in a mandatory examination of discovery in which the evidence and counter-evidence and statements of both sides will be presented. After a period of not more than 1 week, this pre-trial conference will conclude and the trial will commence.
Step 6. Issuing of public summonses. No person or agency may be lawfully summoned into common law court without first receiving a complete set of charges being brought against them and a formal notice to appear or writ of public summons. Such a summons outlines the exact time, date, and address when and where the trial will commence. The public summons is applied for by the plaintiff through the court registrar. The summons will be issued under the signature of the court adjudicator and delivered to the defendant by the court sheriff within 24 hours of its filing in the court registry by the plaintiff. The sheriff must personally serve the defendant or post the summons in a public place and record the posting if the defendant avoids service. The defendant has 7 days to appear in court from the date of service.
Step 7. The trial commences. Opening argument. After an introduction by the adjudicator, the trial commences with opening arguments by first the plaintiff or prosecutor and then the defendant. The adjudicator and both counselors will then have the chance to question either party for clarification and to make motions to the court if it is apparent that the proceedings can be expedited. Note, Step 7 can still occur even if one side, usually the defendant, is not present in court and refuses to participate. Such a trial being conducted in absentia remains a legitimate legal procedure once the defendant is given every opportunity to appear and respond to the charges and evidence against him. And an in absentia trial will commence with the plaintiff presenting his opening argument, followed by the central case. The court-appointed defense counsel will then be given the chance to argue on behalf of the absent defendant if that is the wish of the latter. It is often the case that a non-response or non-appearance by the defendant can result in the adjudicator advising the jury to declare a verdict in favor of the plaintiff on the grounds that the defendant has tacitly agreed with the case against him by not disputing the evidence or charges and by making no attempt to appear and defend his own good name in public.
Step 8. The main proceedings. Assuming the proceedings are not being conducted in absentia and the defendant is present, the main proceedings of the trial then commence with the plaintiff's presentation of the details of his evidence and argument against the defendant, who can then respond. The plaintiff may be assisted by the citizen prosecutor. After his presentation, the plaintiff is then cross-examined by the defendant or his advising counsel. Following cross-examination, the defendant presents his case with or without his advising counselor, and in turn is cross-examined by the plaintiff or the citizen prosecutor.
Step 9. Closing summaries and arguments to the jury and final advice by the adjudicator. After the main proceedings, the adjudicator has the chance to further question both parties in order to give final advice to the jury. The plaintiff and then the defendant then have the right to go give their closing summary and argument to the court. The adjudicator closes with any final comments to the jury.
Step 10. The jury retires to deliberate. The court is held in recess while the 12 citizen jury members retire to come to a unanimous verdict and a sentence based on their appraisal of all of the evidence. There is no time restriction on their deliberations, and during that time they are not allowed to contact with anyone save the court bailiff, who is their guard and escort. The jury's verdict and sentence must be consensual, non-coerced, and unanimous.
Step 11. The jury issues its unanimous verdict and sentence. The court is reconvened after the jury has come to a verdict. If the jurors are not in complete unanimity concerning the verdict, the defendant is automatically declared to be innocent. The jury spokesman, chosen from among them by a vote, announces the verdict to the court, and based on that verdict, the final sentence is also declared by the jury.
Step 12. The court adjourns and the sentence is enforced. Following the announcement of the verdict and sentence, the adjudicator either frees the defendant or affirms and authorizes the decision of the jury in the name of the community and its court, and instructs the sheriff to enforce that sentence. The adjudicator then dismisses the jury and formally concludes the trial proceedings, and the court is concluded. The entire record of the court proceedings is a public document accessible to anyone and in no way can be withheld, altered, or compromised by the adjudicator or any other party.
A note on common law enforcement. It is understood that every able-bodied citizen is obligated and empowered by natural law to assist the court sheriff and his deputies in enforcing the sentence of the court, including by ensuring the imprisonment of the guilty, the monitoring of his associates, and the public seizure of the assets and property of the guilty and his agents, if such is the sentence of the court. This collective law enforcement is required in the interest of public safety, especially when the guilty party is in an entire institution or head officers of that body. And we continue with a note on appealing common law court decisions. Under the doctrine of natural law, in which every man and woman is born with an inherent grasp of right and wrong and of justice, it is understood that a jury of 12 citizens, when given the complete evidence and facts of a case, will arrive at a just and proper verdict. The truth of that verdict must stand and is not subject to reevaluation or dispute, except in the case of a gross dereliction of duty, or non-consideration of evidence. Therefore, the verdicts of common law court juries are not subject to appeal or revision, since the truth is not mutable or reformable. This solidity of a verdict is also required by the common law doctrine and custom of stare decisis, meaning the decision stands, whereby the precedent decisions of previous court verdicts have binding authority. Without stare decisis, the law is subject to the victims and political interference of rulers and despots.
In the words of Black's Law Dictionary, the doctrine of stare decisis states that legal decisions are binding and shall not be reversed. The decision stands. That is, once a court has entered its judgment upon an issue, it shall not reverse itself. This is, in fact, the foundation of legality in the common law system, and is one of the principal differences between common and civil law. Verdicts, enforcement, and convicting rulers and institutions. Every legal system operates according to its own worldview and essential purpose. In the case of civil or statute law, the contending interests of individuals waging war with one another in a courtroom defining the process and names of the court. This system serves whoever has the most money or influence to present the most convincing case, usually before a single magistrate who is part of the self-governing and unaccountable judicial clique. The law, under this elite-derived system, is a private weapon to wield against another person or group over commercial interests, not an avenue of justice for all of the common good.
In the common law, contrarily, the court is defined not by contending individual interests, but by the needs of the community as a whole, and by justice as defined by those who have suffered from the lack of it. A bedrock of collective morality shapes how the common law operates according to a simple issue. Will this legal decision and precedent best serve the community as a whole and those within it who are the most vulnerable or who have suffered or been victimized or who may be? Men and women have a natural tendency to resolve their differences and mediate disputes among themselves when coerced and left to themselves to apply their own natural sense of right and wrong. Despite this, the state has, under threat of force, violently conditioned people to automatically deny their own judgment and defer to external authorities whenever they are in dispute or they seek justice. And so a long relearning of freedom is needed for common law to become a functional part of human life again.
Fortunately, we have found that the very act of publicly declaring and establishing the supremacy of the people and their common law has sparked that process of relearning freedom in the hearts and minds of growing numbers of people. Sparked, but not secured. For the greatest impediment of the efficacy of common law court lies in the fears and doubts that seize citizens when they are presented with the power to be the law, and not have the law be done to them. Taking the law into your own hands, we have been taught wrongfully, is a violation of civil order and tantamount to anarchy. In reality, for citizens to judge legal matters for themselves is the highest civic virtue and the cornerstone of true democracy, according to the Athenian lawmaker Solon. The latter even believed that citizens should be fined or reprimanded for shrinking from a public controversy or from their inborn capacity to be lawgivers.
At the heart of that personal responsibility for the law is the capacity of citizens to judge a lawsuit for themselves as sworn jurors and impose a verdict and sentence in such a suit. The jury system has always been the purest expression of the common law, and its capacity to empower the people themselves to defend traditional liberties and ascertain the truth of a matter. To render a fair and reasonable verdict, anyone simply needs to know all the facts and the evidence and consider it all as soberly without threats, influence, or coercion. The more people who gather to determine the truth of a matter, the more likely they will come to a just and truthful verdict. It tends to be the case that individual bias or prejudice, which is always present and undeniable within a jury, becomes, through the jury process, counterbalanced and absorbed into a broader collective truth, imposed by the natural reason and fairness among jury members.
Enforcement. The big and thorny issue, of course, is not whether men and women can come to a court verdict, but rather how their decision can be enforced and effective in their community. This is especially an issue when the verdict is imposed against heads of church or state or even entire institutions, as in the February 25, 2013 verdict of the International Common Law Court of Justice concerning genocide in Canada. For more information on that, visit www.itccs.org. To use that case as an example, the moral weight of the verdict was clearly the strongest weapon in the arsenal of the court and created the conditions for the enforcement of the verdict against 30 officials of church and state named in the indictment. For one thing, the February 25th verdict of 2013, which sentenced all the defendants to public banishment, 25 years in prison, and the loss of all property and assets, directly helped depose not only Pope Benedict, Joseph Ratzinger, but the most powerful Catholic cardinal in Rome, the Vatican's Secretary of State, Tarcisio Bertone, who also resigned while in office after the International Common Law Court of Justice verdict was pronounced.
Ratzinger and Bertone know about international law even if others don't. They understand that the verdict of the International Common Law Court of Justice carries a recognized legitimacy under the law of nations and the public right to form tribunals of conscience when governments and courts refuse to address a matter. And the Vatican also knows that the International Common Law Court of Justice verdict can be entered into other nations' courts and used for the issuing of arrest warrants against proven war criminals like church officials. And so the resignation of these ostensibly untouchable church leaders in the spring of 2013 is simple proof of the power of independent common law court verdicts.
A court verdict, after all, is a binding order carrying with it the full force of the law, and whoever ignores or subverts such a verdict and the court's orders arising from it is guilty of an indictable offense. In the appendix to this manual, online, we have a reprint of all the court documents related to the first International Court of Justice case of genocide in Canada. The court order and arrest warrant dated March 5, 2013 can be acted on by any sworn agent of the International Court Law of Justice or whoever such an agent appoints. Any citizen, in short, can assist in the arrest of Joseph Ratzinger, Tarcisio Bertone, and the 28 other officials of church and state found guilty of crimes against humanity by the International Common Law Court of Justice. Such enforcement of the law by citizens themselves is generally recognized in most countries under the precedent known generically as the right of citizens' arrest. In Canada, for example, under the law known as Citizens Arrest and Self-Defense Act, 2012, citizens can detain anyone who either commits a crime or is even suspected of having done so, or who poses a threat to their own safety or others' safety, like, for our purposes, a child-raping priest. This power of citizens' arrest has in fact been broadened under this new Canadian law from what it previously was.
And there's a link there in the manual for you to explore further. In theory, then, the enforcement of common law court verdicts by any citizen is not only perfectly legitimate and lawful, but is guaranteed even under the laws of the countries dominated by civil statute law. But power, as we know, is not only about laws and theory, but ultimately involves naked force, the capacity of one group to impose its will upon another. Hugh Grotius, a 16th century pioneer of international law, said that legal principles acquired power only when backed by cannon fire. So besides its legal and moral weight, what cannons will back up and enforce the verdicts of our common law courts, especially when the firepower of those we are sentencing and arresting is apparently so much greater than our own?
Another great pioneer, the Chinese general Sun Tzu, wrote millennia ago that in any conflict, power is not ultimately what you have materially, but rather psychologically, and the superior firepower of a much bigger enemy can always be negated with the right unforeseen maneuvers. Those rulers indicted by the International Common Law Court of Justice are men and women garbed by the illusory robes of their offices, and they are guarded by other men and women who, like the rulers themselves, are motivated primarily by fear. That fear is their greatest weakness and can be easily exploited by even a small group of people, as anyone who has occupied a Roman Catholic church learns very quickly.
The fact that laws guard the rich and the powerful is not as important as the reality that any functional law rests upon its moral and political legitimacy. Once such legitimacy is weakened or gone, the laws and hard physical power of a state or church begin to crumble. Once public confidence in a ruler wanes, internal divisions appear in the ruling hierarchy, and usually a palace coup occurs and the regime falls. We are witnessing precisely such developments and such a collapse of legitimacy within the Roman Catholic Church today, in the manner of events prior to disposing of any dictatorship. And so the short answer to the question, how do we enforce our verdicts in the face of the power of the enemy is simply we do as Sun Tzu teaches and strike at the weakest, not the strongest part of that enemy.
The weak point of any institution, especially a church, is its public image and its source of money. Threaten either, and the entire institution must respond to the smallest of enemies. We have proven that in practice, and the very fact that our smallness gives us a freedom and flexibility to strike at such big targets when and how we like, a power that is denied to big institutions. A common law court verdict, like the one on February 25, 2013, is a wedge between the credibility of an institution like the Vatican and the rest of the world. Clearly, by striking at that credibility, a weak link in the Church's chain, we are maneuvering around the obvious strong points of that opponent and hitting them where they have no defense. The fact that, as an organization, they officially protect and aid children or child rapists and human trafficking. And it was precisely by doing such a strategic maneuver that on August 4, 2013, the Vatican was declared a transnational criminal organization under international law. And you can visit the itccs.org for that. As such a criminal body, the Vatican now can be legally established, its officers arrested, and its property and wealth seized, not simply under common law, but according to the law of nations. See the United Nations Convention Against Transnational Organized Crime, November 2000, Articles 5, 6, and 12.
And there's a link included for you to explore further in this document. So while it isn't normally possible to immediately detain heads of states or corporations after a sentence is passed against them, such an arrest does follow naturally as their credibility and protection diminishes. Their overt power tends to crumble as the law and public condemn works around their strong defenses and undermines them like water flowing around a wall or a rock. The point of any common law court verdict, after all, is not to target or imprison mere individuals, but to stop any threat to the helpless and to the community, to arrest such threats so that they do not reoccur, primarily by ending the institutional source of those threats. And our chief means to do so is the moral weight of our evidence and verdicts combined with the capacity of many people to enforce those verdicts.
Common law sheriffs and peace officers. That brings us to a key aspect of the court, its police arm, without which it cannot function. The tradition of common law sheriffs is an old one in the English-speaking world. Men and women are appointed from the local community to detain those harming others, bring them into town or shire courts for judgment, and enforce that court's sentence. In the United States, that tradition is still alive and embodied in locally elected sheriffs who are granted considerable power within their communities. The role of common law court sheriff is fourfold: to provide security for the court, to deliver court summonses and orders to appear, and to detain and physically deliver to court those summoned who evade a court order, and finally to enforce a final sentence of the court, including by jailing and monitoring the guilty. The sheriff does not perform these duties alone, but with deputies and other agents he appoints to assist him. Such a posse is another pejorative term that actually refers to an important traditional custom of mobilizing all the able-bodied men in a community to stop anyone who has committed a crime. The word posse comes from a Latin term pro toto posse suo, meaning to do the utmost in one's power.
According to one writer, all persons who were the victims of a crime in Anglo-Saxon England were expected to raise their hue and cry and apprehend the criminal. And upon hearing their cry, every able-bodied man and woman in the community was expected to do the utmost in his or her power, pro toto posse suo, to chase and apprehend the accused as a posse. And that's quoted under year 1215, the year of the Magna Carta by J. Dassinger et al., 2003.
The custom of electing community peace officers, like sheriffs, in other words, arose from the belief that everyone in the community had the obligation to police and protect themselves and their children. The court sheriff is thereby the servant of the people, taken from among them, answerable to and recallable by them, and not an external force over them. Part of the power of such a sheriff is that he can deputize anyone to assist him, including other police officers and agents of the very institutions being named and tried in common law courts. This is an essentially important action and tactic during the early stages of the development of our common law courts, since it uses the very strength of the system we are opposing against itself.
To give an example, if a common law court summons or arrest warrant is to be delivered against a church or government official, the court sheriff will first deliver a copy of it to the local existing police agency along with a deputizing notice placing those police under the jurisdiction of the common law. You can see Court Documents Appendix B for more. As such, the police are then obligated to assist the sheriff and must take the same oath of common law office as the sheriff. If those issued such a notice deny or dispute or refuse to take the oath, they are then ordered to stand down from their position and to not interfere with the sheriff in his duties. If they agree with the notice, either directly or through their silence or non-interference, such police agencies are tacitly abiding by the common law action, and the normal protection around criminals in high office is suddenly nullified.
Such a remarkable encounter is in effect an enormous tug-of-war between two contending legal systems. A battle of wills played out in full public view as an enormous teaching moment. Our aim is to create and encourage such a creative confrontation and moral conflict at every level of official society. This is the bigger and crucial point of that particular confrontation between court sheriffs and civil law policemen, which must always be visible and televised to the world as it occurs. That it is a chance for the people to learn directly that those policemen and soldiers who provide the muscle for the system are not exempt from the authority of common law and must ultimately make a choice concerning who and what they serve. The moral and propaganda value of publicly posing such a question is inestimable.
On those occasions when this tactic has been tested in Canada and elsewhere, the results have been always the same. The police back off and do not interfere. Time and again, neither the Royal Canadian Mounted Police nor the Vancouver Police have interfered with protesters who peacefully occupied Catholic or Protestant churches responsible for the death of Indian children. On one occasion, a senior police sergeant even stated that if the church had committed such crimes and were served with such a court order, he'd be duty-bound to enforce such an order and help arrest those responsible. Again, quoting Sun Tzu, to defeat an enemy, one must know them, and such knowledge can only be gained through constant contact. Provoke them to learn their responses. Prick them to test their strength and weakness. Do not outfight them, but outthink them.
Common law peace officers return power to the people by making them their own police authorities. In doing so, they challenge the very basis of the status quo and its elite-based rule by undermining those unaccountable armed bodies of men who constitute the final and ultimate power of the state. The common law, in short, is the seed of fundamental social and political transformation, not simply a weapon of self-defense for the oppressed.
On citizens' arrests, The right and necessity of citizens to detain suspected or actual criminals has long been recognized under both civil and common law. For examples, as mentioned, under a recent law in Canada, the Citizens Arrest and Self-Defense Act of 2012, the right of citizens to perform arrests and detain suspects on their own has been broadened to include not only people caught endangering the community or harming others, but anyone suspected of crimes, including known offenders.
Under the same common law custom of pro toto posse sui that empowers any group of adults to unite and stop those causing harm, the right of citizen's arrest is not restricted or negated by a higher authority because of the recognition that any man or woman has the competence and obligation to see and directly halt wrongdoing in their community. The procedure for performing a citizen's arrest is as follows. 1. One must first either witness a crime or recognize a suspected criminal or known offender, or even have a reasonable suspicion that such persons pose a danger to others. Such a suspicion might be based on probable cause and not simply a feeling or prejudice about someone.
2. One must then inform the suspect or offender that he or she is being placed under citizen's arrest under the right of necessity to defend, which obligates the arrestor to detain the suspect or offender. The arrestor must state who they are and why they are exercising the power of arrest by stating the cause of action.
3. The offender or suspect must then be detained and held for trial in a common law court if they turn out to have committed a crime or pose a danger to others. The amount of force used in the arrest must be a reasonable response to the suspect's behavior. Citizens
can normally hand over those they have detained to an authorized common law peace officer or a sheriff of the court. The arresters must be willing to appear in court and give sworn testimony concerning their actions. The crucial importance of the power of citizens' arrest is that it trains and empowers citizens to take responsibility for policing their communities and for the law itself. It moves democracy from theory to action.
Broader consequences of the common law court. A world made new. Our first real step towards independence from England was the establishment of our own republican courts. Right under the nose of the Brits, we set up a different legal system of our traditional Brehon laws, even while under military occupation, and we had to defend that system in arms. So you can say that once we started living under our own laws, everything else had to follow, right up to becoming a new nation. For what you call the law is but a club of rich over the lowest of men, sanctifying the conquest of the earth by a few and making their theft by way of things. But over and above these pitiful statutes of yours that enclose the common land and reduce us to poverty, to make you fat stands the law of creation, which renders judgment on rich and poor alike, making them one. For freedom is the man who will thus turn the world upside down, therefore no wonder he has enemies. That's written by Gerard Winstanley, The True Levellers, Standard, Surrey, England, 1649.
For the people themselves to sit in judgment of historically untouchable rulers like popes and heads of state, and to render an enforceable verdict on their crimes is a revolutionary act. And such a revolution has begun with the February 25, 2013 verdict of the International Common Law Court of Justice. We cannot shrink from or deny the profound consequences of taking such a necessary historic step. Rather, we must recognize that the new judicial system in our hands is in fact a doorway to a transformed world in which the land and its wealth and society as a whole is reclaimed by all people and brought into harmony with natural justice through a great social leveling.
Many traditions and prophecies foresee such a time as now as a judgment upon the corruption and injustice of the human world. Biblically, such a moment was known as the Jubilee, when all human laws and divisions are abolished, and society, like nature during a fallow year, is allowed to rest from warfare, corruption, and injustice. In truth, we recognize this historic moment not only as a condemnation of what has been, but primarily as a transformation into what is coming to be, a reinventing of humanity according to the simple principle that no law or authority shall ever again cause anyone to rule, harm, or dominate others.
The aim of common law is to reestablish direct relations of mutual aid among people by placing justice and the law within their reach. Again, and that devolution of power will simultaneously disestablish all hierarchical institutions of state, business, and church which control and mediate human life as a power over people. A process so profound and revolutionary can only be enacted from the grassroots, that's you and me, by many people who have relearned freedom and used it to take action in their own communities to govern themselves as their own judge, jury, and police. On the basis of this good, renewed soil, a great harvest will one day arise in the form of new and local republics of equals, in harmony with itself and all creation. The common law is a catalyst and a means towards achieving this political and spiritual end.
For now, as we struggle to give birth to the courts that are like a great plow, plowing and breaking open the dead soil of the status quo, we must never forget that much of what we have been taught will betray us. For we have been raised as slaves to think and operate under laws that serve the few. Everything must be rethought and retried according to the two great principles of natural law. All things are placed in common for the good of all, and therefore the law shall cause harm to no one. Our principles are firm, but our methods and tactics are supple. We must audaciously try ever new ways to expose, indict, and stop criminal institutions and corporations that are killing our planet, our children, and our sacred liberties. And together we must learn from every mistake and defeat and generalize the victories and wisdom we gain into clear precedent throughout this long redemptive struggle that will span many lifetimes.
The conscience born into us is our lamp during this journey and our best instructor, as in our great heritage of natural law and reason passed down to us so that a free and independent humanity may never perish from the earth. Armed with this truth, this knowledge, and this sacred purpose, each of us is to go forth and take action. You have a world to win back.
We have a world to win back.
We have a world to win back. So I would just like to add at this conclusion, there's an appendix with sources and resources that you can go and study further if you like. We trust that you found this reading of the Common Law Community Training Manual educational. We encourage you to look at the areas of concern that are most important to you, whether it's fracking or the Fukushima cover-up, genetically modified foods, chemtrails that fill our skies day and night.
Government abuse, police abuse.
Child trafficking. There's so many issues out there. You know, mind control, electromagnetic pollution from cell towers and phones. Anyhow, so the bottom line is that you can go and read this manual, and then what you can do is you can volunteer to become a deputized peace officer, which the ITCCS will provide for you. And then what you can do is help to end these crimes against humanity and nature. The natural systems we all depend on for life are threatened, and so it's up to each of us now to come together and to cooperate and to make this happen. On our own, individually, our voices are not heard. However, together our voices are unstoppable. So I don't know if there's anything else you would like to add?
My word is my sword.
Awesome. Okay, so thanks for listening. Please share this video series with as many people as possible. We need to get the word out. We need to educate ourselves, and we need to bring back common law.
Great.
Thanks for listening.
Thank you.